Evening, everyone. My name is Bawedi, and on behalf of AFSA, HKA, CIR, South African branch, Pinson Masons, and Combat, it is my pleasure to welcome you this evening. This evening, we'll be tackling a topic that is fast changing how we do things, the role of AI-generated evidence in arbitration. Now, as we all know, if AI can do most things that we can and can't do. It's generating contracts, it is generating contracts, it is determining outcomes, it's preparing presentations, it is even preparing expert reports that we would not be able to do. Now, this leads us to one very important question. How do we use AI-generated evidence in arbitrations, or do we even use AI-generated evidence in arbitration? And if we do, who's responsible for assessing the validity and authority of information? And lastly, if the AI gets the information wrong, who's responsible for that? Now, tonight, we are honored to have a brilliant panel of experts who will help us who will guide us through this topic. I'm going to hand over to our moderator for the evening, Sonia Guerrera, who is a director at HKA. She's also a committee member at CIR South African branch. Over to you, Sonia.
Thank you, Babedi, for that lovely introduction. And thank you to AFSA for all your efforts in putting this event and this evening together. Good evening, ladies and gentlemen, and welcome to tonight's discussion. Very excited to have you all here and everyone joining online. Thank you, and in person. We tonight have a very interesting topic. Artificial intelligence is moving rapidly from theory to practical use in drafting, data analysis, and dispute management. This evening, we're joined by a distinguished panel to explore how arbitration bodies, lawyers, counsel, and experts can responsibly integrate AI in evidence without losing sight of fairness, transparency, and human judgment. So before I move on to introduce the panel, can I just see by a show of hands here in the audience, who here has used AI tools in your work? All right, someone in the audience is using it at the moment as we speak. And just for everyone online, we basically had everyone's hands raised, so thank you. Now, please allow me to introduce my awesome distinguished panel. On my left is Svetlana Vasileva. She is the Secretary General of the Arbitration Foundation of South Africa, as we know, AFSA. With over 28 years of international legal experience, she has led legislative reform and arbitration initiatives across Eastern Europe and Africa, and holds 2 LLM degrees. A certified mediator and ISO 901 lead auditor, Svetlana is multilingual and actively serves in leadership roles with global legal organizations. Welcome, Svetlana. Next, and joining us online is Darren Mullins from HKA. He's a partner and a certified computer examiner with 15+ years of experience in digital forensics. He has provided expert testimony in litigation and arbitration across Europe and the Middle East, and led investigations into financial crime, data recovery, and electronic discovery. Next up, we have David Quest Casey, also joining us online. He's the joint head of chambers at 3VB and our COMBAR representative. He's a leading commercial barrister with deep expertise in high-value litigation and arbitration. His practice spans banking, fraud, trade, and offshore disputes. Appointed Deputy High Court Judge in 2023. He is consistently ranked in top legal directories. And last, no, not last but least, second last, Brandon White, a senior associate. He's here in person. Is a senior associate and notary public at Pinson Masons, Johannesburg, specializing in litigation and ADR. He has extensive experience advising on construction disputes, contract interpretation, and project counsel for infrastructure and mining projects. locally and internationally. And then last but not least, joining us online as well is Carlos Calvero, is a head of expansions at Shadu, Clio, and serves on the CIARP London branch committee. He contributed to the CIARP guidelines on AI in international arbitration as part of the technology and ADR specialist group. We will also hear more from Carlos on these guidelines tonight. So ladies and gentlemen, together, the panel represents a fantastic cross-section of dispute in the industry, from arbitration bodies to practitioners, consultants, and experts. So please, let's give a round of welcome to our fantastic panelists. So let's begin by setting the scene and understand what AI-based evidence really means in South Africa arbitration. Yeah, I think I just have another question that I want to ask before we start. Oh, no, okay. Sorry, I'm going to multitask with the Mentimeter and running the panel tonight. So let's start with the context of AI and arbitration, defining AI evidence in South Africa. Brandon, if I can start with you. In the South African arbitration context, does AI-based evidence really refer mainly to AI-assisted analysis, predictive tools, or reproductive outputs such as document summaries? And how should tribunals categorize such outputs as expert opinion, documentary evidence, or a hybrid category?
Well, thanks, Sonia, for the question. First off, the arguments, there we go. Shall I restart, or is everyone happy? It's often used to support our legal arguments and streamline case preparation. So this is where kind of, as AI is coming into the workplace, this is where my main experience has currently been, is it's kind of reducing time taken to digest large portions of our large data packs and kind of sort it nicely chronologically into dates, which helps us prepare for our case management and how we're going to set out our legal arguments. The second option, and maybe the one where from conversations I had outside, I think AI is probably going to go, is it's as a predictive tool. So these can forecast case outcomes. So what they do is, well, what we've had the experience is you feed in a certain type of adjudication in a certain country, and you come across what the general results are. Let's say, for my experience, is payment certificate disputes. Let's say I'd feed in South Africa. We've got lots of payment certificate disputes in adjudication. If I'm the referring party, what is the likely outcome? And AI is getting better and better at being able to kind of give us that answer. And also globally, that's emerging quite quickly. Then the third kind of category that we fall into is its reproductive outputs. So that's where you feed document summaries, draft submissions, and even procedural templates. And these can be generated by AI. So again, in a world where costs are becoming more and more driven, clients want more and more certainty, AI can reduce the time to at least produce first drafts. Obviously, we need to look at those drafts and scrutinize them quite carefully. But that's really where we're seeing the use of AI, at least in our offices at the moment. So if we go from there and we look at the categorization of AI outputs by tribunals. So now we've got the kind of general broad areas where it's used. And we now want to go a little bit deeper into what the kind of tribunals would be looking at. So the first option is AI as kind of an expert opinion. So as I've said, it can come across as an expert opinion. It resembles expert evidence and it can to an extent involve analytical reasoning, such as predictive modeling for more complex data interpretation. So the issue here is that since AI lacks kind of a legal personality and accountability, and I think we discussed this, George, outside, is that a tribunal can't necessarily accept what AI gives you, although resembling expert evidence, it can't accept it on face value as expert evidence per se. Instead, what we've seen, and I think Darren will touch on this later, is the way that it's been used, and I think the way it's currently modeled, is you would have an expert then interpret the data. So it's like someone would explain what the AI process has been, what prompts have been used to come to the data set, and kind of it's an expert, but dealing with how AI has reached its conclusion. So then the second kind of category it can be used is as documentary evidence. This is probably more common, and it gives document summaries, translations, timelines, and often these can be treated as documentary evidence. The key is always to look at, is the data that's been produced, is it verifiable, and is it reproducible? Because if it's not, then there's not going to be any consistency in it, and obviously the trust in the produced data set is not going to be accepted at large. Then the third is kind of, it's a hybrid category. So this classification is being used more globally at the moment. I think it will eventually get here, but it's not necessarily where we're seeing it. And it's used for like outputs that combine things such as factual data with interpretive elements. Now, an example here is an AI summary of case law, which may be documentary in its form, but analytical in its substance. The key for considerations for tribunals when they're looking at these data sets is disclosure. So parties need to disclose at an early stage that they're making use of AI. Human oversight, at least at the moment, we need to have tribunals take the adjudicative responsibility. So you can't just leave that with the AI as of yet. And I'll say as of yet because I have thoughts on adjudication heading that way, at least overseas, and maybe here in the future on less complicated matters. And then you also need to take into account bias and reliability. So AI outputs can reflect training biases and produce hallucinations. And I think there's recently been a few cases in the legal sector where there's been issues with case law being quoted and then that case law being found to not exist. And tribunals need to scrutinize the accuracy of what's being produced. So the other key thing to take into account is confidentiality. So we are talking about this outside, and AI models may compromise sensitive data, especially if they're open source. So it's another thing that's going to become quite key as to how it's used. So, I mean, effectively, I think the kind of approach that should be used by tribunals at the moment is its context-sensitive approach. You know, it's horses for courses. So outputs based on their function and reliability, while holding core principles such as fairness, transparency, and accountability at the heart of any kind of use of AI technology.
Thank you, Brendan. Do we have any of the other panelists that want to add anything? I just need to understand if David or Darren, Carlos, if you want to speak, just unmute yourselves and please just chip in. I'm not sure. Okay. You're welcome.
The institutional perspective, just briefly. So from AFSA perspective, we are seeing the AI-based evidence emerging in all this form. And in practice, tribunal should look first at how the AI tools has been used. And as Brandon say, and if it supports the human analysis or assist the expert reasoning, it should generally be treated as a part of expert evidence. And if produced standalone outputs, for instance, automatically generate reports that might fall closer to the documentary evidence, but with the question around the reliability and provenance. On your question, if that will be seen as expert opinion, documentary evidence, or the hybrid category, on my view, it will be, I think it will fit in the both categories, so a hybrid approach makes sense. The tribunal assessed both the technical integrity and the AI process and the human oversight behind it. So ultimately, AFSA position will be in favor of transparency, disclosure of the tool, data set and methodology to all proper testing of its probative value.
Thank you, Svetlana. And can you just continue to put your views on whether arbitration seated in South Africa has already encountered AI as just a submissions analysis, or are they still in a phase of portion observation? Maybe if you can share some local examples.
Yeah, if I'm honest, in South Africa, we are not yet in the phase where the AI runs through the whole arbitration. We are more what I will call the measure, caution, but curious phase. And what we are seeing so far is that the AI comes in around the proceedings, not into the proceedings. And counsel and expert are starting to use it to make their life easier, as all of us. So to sort and label big construction files, to translate or summarize document, or to produce a first draft of something that is then checked by the human. That supportive use is not determinative use. But we haven't yet seen a case where someone arrives and say, hey, AI, I have AI generate evidence, nor have we had procedural challenges based on AI so far. On the institutional side, we keep things quite controlled. We haven't put generative AI into the secretariat work, and tribunal appointments, party communication, or the fee decision are still entirely by human. What we are using AI-enabled feature built into the tools we are relying on, for example, Acrobat Pro smart functions. As soon as hopefully we will have Microsoft 365 AI layer for filing and retrieval. The reason for that is simple. The volume of the filings keep growing and we must stay efficient. But the golden rule is AI can help, but AI cannot decide. Where we do see faster movement in the research, where we see the faster movement there is in the research and analysis. So African practitioners are already turning to the tools like Jus Mundi for the rapid research, dispute resolution data for the trends and timelines, and arbitrator intelligence for more transparent arbitrator selection. That actually is healthy entry point for AI, and it enhances preparation and transparency while keeping the human touch. So the short version is this: AI is definitely present in our ecosystem, in our everyday work, but it's still in the background. And the next step, and something AFSA is already thinking about, is to give the parties and the tribunal clear guidance. As AI become more visible in submission, we will need to integrate it without compromising the due process and copy compliance, and of course, our institutional integrity.
Well, that's good to hear that it's already relevant and that you've witnessed it and seen it. Thank you, Svetlana. So we've set now the context of AI evidence, and now let's explore the evidential implications of AI evidence. And before I move on to ask the questions to the panelists, if I may quickly share my screen and ask everyone online and in the room to please copy or scan the, just need to see your Mentimeter code. I've lost my screen. Then now can you perhaps open very fast? I'm going to do it once and then we'll speak through the issues. Apologies. Here it is. Thank you, Linga. May I just ask everyone to scan the Mentimeter QR code, or you can go to menti.com and enter the code that's displayed. Maybe just give me a thumbs up. And everyone online as well, please. Okay, let's wait to see. Okay, so we're going to move on. So the first question for the audience: should AI-derived analysis be admissible if the methodology is explained, even if the algorithm is not fully disclosed? So no, yes, or not sure. Now I'll ask everyone to please vote. And then, of course, we will hear from our experts on this. Okay. We're at 26 no, 7 yes, and 6 not sure. I'm glad there are some not sures, because that would have been my answer too. Okay, I'm going to give 2 more seconds, 1, 2. All right, then we're going to move on to the panel. I'm going to stop sharing and we'll move on. How do I stop sharing? That's why I prefer Teams. I'm so familiar with Teams and not Zoom. All right, Denga is going to assist. Thank you very much, Denga. Let me then move on to, okay. All right, perfect. Thank you very much. Let's move on and then let's consider the legal and evidential challenges with AI evidence. So if I can ask David, who's online, my next question: what rules and principles apply to the admission of AI-generated evidence in arbitration? If admitted with probative value, what probative value can be attached to the evidence, particularly where the AI system that generated it may be operated as a black box? And do existing arbitration rules, for example, the IBA rules, cater for this? If not, how should they be adapted? I know it's a mouthful. Thank you, David.
Thanks. It's oh, there's a bit of an echo. We can stop that. Yeah, so I think the short answer is at the moment there aren't any rules or principles, and I think with the exception of the Chartered Institute of Arbitrators guidelines, which I think we're going to come on to later, none of the institutional arbitral rules or the IBA rules in evidence or any similar rules have really explored this area at all, or really contemplate the use of evidence of the kind we've been discussing in arbitration. So I think it's something we're going to have to work out as we go along. And if I might just sort of build on a few of the points that Brendan in particular has made about the different kinds of AI generated material that we might begin to see used in arbitration, because there's going to be different approaches depending on what kind of material it is. I suppose probably the easiest scenario, which I expect probably happening already, is a scenario where you've got counsel or witnesses, and particularly expert witnesses, using AI tools to help in the preparation and the presentation of their evidence, but where the evidence itself is going to be adduced from human witnesses in the normal way. So you're using AI as a kind of assistant there. And I don't myself see that creates any particular problems of principle about using that. Although there will be a question, I think we'll talk about this later as well, about to what extent it's necessary to disclose the fact that people are using that kind of assistance, and how the use of AI tools might impact on the reliability of the evidence that the witnesses are giving. So that kind of consideration is probably the sort of thing that arbitrators should think about exploring with the parties at the outset of the arbitration. And then you've got a more radical possibility, which you might perhaps regard as a little bit far-fetched at the moment, but not necessarily in the future, which is the use of opinion evidence generated by AI. So in other words, in effect, to use the AI in place of a human expert witness. And I think it's fair to say that's, for the moment, would be outside the contemplation of any arbitral system I'm aware of. There are obvious significant difficulties with it in principle. I mean, one of the problems with discussing these things is it's hard to avoid anthropomorphizing the AI and think about it as like a person, but obviously it isn't. It doesn't have any insight into its own operations. It can't meaningfully undertake that it will be truthful or fair or unbiased. And the lack of subjectivity in the process means that you can't really think of it as being opinion evidence at all, comparable to a human expert. And I mean, let's not lose sight of the fact that we're ultimately talking here about a statistical process. That's what lies behind the current range of large language models. All they're doing is generating a plausible continuation of the material on which they've been prompted. So that's probably too far away. On the other hand, and I think this is one of the examples Brendan gave, we quite often see in arbitration expert evidence which is more like expert analysis than it is expert opinion. So classic example would be the use of forensic accountancy experts or other financial experts to synthesize and analyze large amounts of financial data to be presented to a tribunal. And there I think there's a more plausible crossover between human evidence and AI-generated evidence. And no particular reason in principle why a tribunal shouldn't admit that. But there would still need to be considerable caution. As we know, one particular problem with current AI is that they are frequently wrong and frequently plausibly wrong. And indeed, the more wrong they are, the more plausibly they tell it to you. And that's what we talk about when we talk about hallucination. And current models are also quite restricted on what's referred to as context. So that's the amount of specific information outside their training data that the AI is capable of assimilating. And certainly the information in a substantial arbitration would very quickly exhaust the context limits of the current models, which can't really absorb more than about 1 million words or so outside their training data. So they are, these are serious limitations on the reliability of AIs. And another problem, I think, with using them even in that more limited sense is with when you're looking at conventional evidence, analysis or opinion evidence, one judges the reliability normally by testing the reasoning that's led up to the output. But it's quite problematic to extract the reasoning of an LLM because essentially it's acting like a black box. You can't work out what it's doing. And there's a much discussed concept in AI of the need for explainability. In other words, to be able to explain not just what the result is, but why and how the AI got there. And that's problematic in the current range of models. I mean, if you've ever played with them, you'll see that some of the latest releases, like Gemini 2.5 and GPT-5, when you ask them questions, purport to show you a thought process as a human might. But there's some considerable doubt over whether that's actually reflects their thought process or whether it's just another hallucination. And then the final point I was just going to make is I think all of this raises a separate practical problem in arbitration, which is if this material is being presented, what assistance do the arbitrators themselves need to assess the reliability of it? And of course, if you're an arbitrator, you don't need help, or you're not expected to need help to judge the quality or reliability of a human expert. But if you're dealing with AI materials, it's not obvious how you should treat them. And in a sense, it is in itself a separate expert question, which you would need to have evidence of in the arbitration about how reliable the AI generated material is.
Thank you, David. Anyone on the panel wants to add anything? Thank you, Brendan.
Yeah, thanks very much, David. I think you probably used my example a lot better than I did, so that's quite helpful for me. I think you raise an interesting point in relation to the assistance that arbitrators may need. And a lot of the rules and a lot of the arbitration protocols we follow allow for kind of expert assessors to be allocated to the arbitrator to potentially assist with more complicated tasks. So I think it's probably already there, but maybe just needs to develop a bit to allow for an expert assessor on kind of the AI context to assist some arbitrators who maybe are not familiar with the process or have maybe, well, I know if I watch my younger cousins play with my iPhone, it can do a lot more than I can do with it. So I think it's probably the same issue that arbitrators may come into. And I think your point there, David, on kind of the assistance role that arbitrators may need is probably something that parties will have to seriously consider as AI becomes more widely used in arbitrations.
Thank you. Thanks, Brendan. You want to add anything? Darren?
If I could just sorry, I'm going to back feedback as well. So if I could just add actually more to David and to Brendan's points. From and they both address the right way that, of looking at what AI is producing, whether it be standard analysis or assistance for analysis to create evidence that can be tied back to underlying data, and we'll discuss that package a little bit later on. But the second part, which I think is quite interesting, is that opinion part that both Brendan and David mentioned, and where AI is producing opinion. It is tied back to this impression of a black box. But to follow on from David's point, there is now a growing stream of science into explainable AI, and I think that requirement for an expert in that field will be key to explaining that. So there are a number of different logical steps that can be taken. Both logical, statistical, and utilizing more simple AI models to start to address the decision-making processes of larger models. So again, it will be a new field, and I think there will be experts in that field who will be able to assist arbitrators in their decision-making when we're solely focusing on opinion-based or opinions provided by AI.
Thanks, Darren. And while I have you on speaker, and something that David's also touched on, if you can maybe just give us your view on whether an AI output ever stand unaccompanied, or must a human expert always interpret and take responsibility?
Yeah, I think
Darren?
in current, the way we are currently, and I think current situation, current technology, current standard of AI output, there is no way that it should stand alone without that human in the loop element. From an evidential perspective, that human QC aspect and the human expertise behind the QC elements, again, which we'll touch on in a little bit, is absolutely required for that for that evidence to be trustworthy. Brendan mentioned it at the start that it needs to be reliable, it needs to be transparent, and it needs to be repeatable. And those are the three key areas from a forensic perspective, anyway, that we would need to judge AI, the evidence produced by AI, or evidence that's been used, or that AI has been used to analyze, so that's, as I said, we have that trustworthy aspect to it. Where I think things may move, and where things will change, and again, I think Brendan alluded to it, is where we'll be in a position that AI is in a much more has a much more transparent thought process to be allow us to be able to review that. It may be a point where we can use multiple AIs to cross-reference opinions being provided. So, for example, one LLM providing a result to further LLMs checking that output with a further deterministic view to be made as to that opinion being accurate, and all of these things will be addressed, I think, and can come into future aspects. But from my perspective, from an expert perspective, from a legal perspective, I think we should never have that output without a human in the loop element.
Well, I think that's good to hear, because I think a lot of us, myself included, are worried about how AI is going to take over a lot of roles and our lives. And it's good to know that there's some human aspects that still need to be involved and not going to take over the world right away. So if we can move on, I would like to hear from Carlos on the CIR guidelines. Carlos, if you can briefly just give us an explanation on the following, that the guidelines, where the guidelines emphasis that users, including arbitrators, remain fully responsible and accountable for outputs produced by AI tools. How should tribunals enforce this responsibility in practice, especially where generative AI is used in expert reports or pleadings?
Yeah, sure. Thank you for having me here. So I think on the accountability issue, that was, I think, one of the least controversial points during the drafting the guidelines within the committee. Because I think, and I hope everyone agrees, that using AI doesn't remove responsibility. People remain responsible. Of course, and there are some, maybe some futuristic examples in which you might have standalone AI, but they're not here yet. I don't think they will be here anytime soon. As Darren mentioned, in the current state of affairs, the way international arbitration and legal in general happens nowadays, that doesn't seem realistic just yet. So it becomes, even though it's something so straightforward, we have to put it on guidelines and things like that, just because, as David mentioned, because AI is such a cool technology that always gives you consistently plausible answers. People might mistake it for something that they could use it without checking. But if you're a good lawyer, if you're a good expert, if you're a good judge or arbitrator, you should always check the work yourself, and maybe think of AI like a smart assistant. It's helpful, but the person signs the work.
Thanks, Darren. And sorry, apologies, Carlos. The guidelines also empower the tribunals to regulate and even require disclosure of AI use where it could influence evidence or decision-making. How far should disclosure go? Must parties reveal prompts, underlying data sets, or risk audits?
Yes. So if accountability was one of the least controversial, disclosure was one that we had a lot of different opinions, because of course what needs to be disclosed will change with time. Right now there are some novelty, there law firms using AI for new things. And of course, everyone thinks that they should be disclosing those. But when that becomes common and everyone is using the same tools and using for the same use cases, that might not need to be disclosed. So right now, the guidelines have to be a little bit generic about that. So basically be clear about where AI is used, but don't open everything up unless needed. So according to the guidelines, which was if followed by a procedural order requesting disclosure, a AI use note should be issued by saying what tool they used and for what purpose. Maybe drafting, maybe reviewing, but we don't think that full access to prompts or all data should always be required. Only when the AI work is directly part of the dispute or its reliability is in question. The tribunal has the power to ask for more detail if needed and can impose consequences if a party don't comply. But the key here is proportionality. There must be enough transparency because there is a potential for AI usage to compromise the proceedings, but without unnecessary intrusion on the ways that people do things in their own law firms or chambers.
Thank you, Carlos. And does any of the other panelists have anything to add in terms of accountability or procedural direction and disclosure? Okay.
So it does appear, so I've always got something to say. So,
Thank you, Brendan.
yeah, so I mean, I've heard it described quite nicely, and Carlos maybe ties into what you say when you say we always need to check it. Is AI as it currently stands is like a very, very smart toddler. So it's going to give you a really good starting place. But as you say, at the moment where we stand, you still can't get away from having to check that work. And I think you're right there, Carlos, and I think that's probably the key at the moment is if we're not checking that work, then these plausible issues are going to come in more and more often, and then we're going to have to regulate harder. So I think it's going to have to be used responsibly at the moment.
Thank you, Brendan. Then I will open this question to the whole panel in terms of confidentiality and data security. So confidentiality is the cornerstone of arbitration, yet the guide warns of material risks when confidentiality or confidential data is fed into third-party AI systems. What practical due diligence should parties and counsel conduct before selecting an AI platform? And should institutions like AFSA mandate minimum security standards? Maybe Svetlana, I'm going to start with you. Thank you.
That is a very important question from institutional perspective, I would say, and it really sits at the intersection of the trust and the technology. And from AFSA perspective, the confidentiality isn't just a procedural expectation, it's a legal obligation. And this is grounded in our rules and also in South African Protection of Personal Information Act, POPIA. So when we look at the AI or any digital platform that process arbitral materials, the starting point has to be full compliance with POPIA. Core principles like security, purpose, limitation, and accountability, which also mirror the broader African and OECD standards highlighted in the International Bar Association African Regional Forum Data Protection Guide. Practically, before any party or tribunal adopts an AI platform, according to these guidelines, a few classic basic due diligence questions must be asked. First, where is the data stored, locally or offshore? Is it encrypted both at rest and in transition? Does the provider comply with the ISO 27001 or with equivalent security standard? And who retain the control and deletion rights over the uploaded material? And critically, does the contract prohibit model training and on the arbitration data? This is not just theoretical concern. They come straight from International Bar Association cybersecurity guidelines, which urge verification of the cloud provider security, jurisdiction, and access control. In AFSA view, or my personal view, institutions should set a baseline, not to prescribe a single technology, but to ensure that the minimum security assurance are built into the every use of AI. That could take the form of a short annex or the protocol aligned to the International Bar Association cybersecurity protocol and the CRA AI guidelines, but adapted with the South Africa through the POPIA lens. So our message to the users from institutional perspective will be simple. AFSA support innovation, but under secure by design principles, and AI can only serve arbitration if the confidentiality of the party data is protected at every single step.
Thank you, Svetlana. That's good to hear on the South African perspective. Brendan, have you come across any security standards?
So I think building on what Svetlana's talked about is one thing to bear in mind is probably data minimization, which would be required under POPIA, which is only minimum necessary personal data should be processed. So this is going to reduce any exposure of risks. Also, insofar as I guess you could look at it how you look at current evidential principles. If there's things I don't necessarily want the other side to see, but there is some oversight required, we could look at things like confidentiality rings, where the tribunal would say, well, disclose it to the other side's lawyers so they can see what's being done, or disclose it to the other side's expert under something like the principle of a non-disclosure agreement, where I think that could maybe take away some of the kind of dark arts of what's happening behind the AI screen. And I think that's probably where I see some of the issues and how to maybe deal with some of those issues as we are now.
Thank you, Brendan. Carlos, do you have anything to add?
On the, can I just mention something on the confidentiality and data security? Because I think this is not a new issue in arbitration, right? So I've been working with legal tech providers for many years now. And every time we're hired by a law firm, we go through extensive like due diligence. They check security standards, certifications, data processing terms, and so on. So both sides are, covered by those internal policies within law firms. But the arbitrators are not necessarily using the most updated system. They might not be guarded by that. So if you put confidential data into an AI tool that hasn't been verified by the law firm, you must treat it like you're basically exposing the file if you haven't taken the measures to confirm where that data is stored and so on. So I think we put in the guidelines about confidentiality and data security also as an informative session, both for arbitrators, because arbitrators are usually not under the scrutiny of the law firm to follow those policies, but also for lawyers, right? Working in law firms, the same law firms that sometimes go through all this process to hire legal softwares, to contract with legal softwares. If a lawyer from that law firm goes online by itself and start inputting sensitive confidential data in other providers that haven't been verified by the law firm, that brings into the process a lot of issues and a lot of risks. So I believe confidentiality and data security are two key aspects of using AI responsibly.
I totally agree. Thank you very much,
Can-
Carlos.
Can I just add one point to that?
Yeah.
I may? Because I completely agree with Carlos that the data security is hugely important, but it's not a new thing. And in a sense, it's as important in all data storage scenarios to make sure you're paying proper regard to confidentiality. I think that the particular AI angle in the early days of AI was the concern that people were putting confidential data into free public AI models where nobody really knew what the suppliers were doing with the data when they put it in. And obviously that was foolish. Obviously things have moved on now, and all of the suppliers are now much more focused at producing, for those who prepare to pay for it, enterprise grade products with proper audited security. So it's really just a the issue really is just applying the same kind of care that you would do with storing your files conventionally or sending confidential emails to using AI products. But it's all there if you want to use it.
If I could just add, yeah, Tanya, thank you. So actually just tying all of that back into an actual real world case, we do have a case at the moment in the UK High Court where we were specifically using a platform that we did have to vet, that the lawyers did have to vet. And as David and Carlos have mentioned, the platform itself, obviously being an e-discovery platform, had gone through the numerous checks from a data security perspective. But the real challenge was confirming and proving that not only was the transfer between the platform and the LLM secure and not through any kind of public facing application, but that contractually the LLM owners, whether it be OpenAI, Anthropic, any or Google, that contractually those owners could not take that information, they could not take that data to use in any manner, whether it be to train further large language models or for any other means. And that aspect was key to the allowance of us to provide the assistance that we did for the High Court case.
I've also experienced a lot of times where I wonder what is the security risk by using or uploading certain information to the AI, and especially when it comes to work related matters. So I think this was very valuable to hear some insights on the security aspects. And let me then move on to the cross-examination. If I can ask David, if you can tell us how do you cross-examine evidence generated by an algorithm, please?
Well, how would I? I've not yet had the opportunity to do it, but I think just to be clear, what we're talking about here, I think what we're really saying is that can you test AI generated material by querying it in the same way that you could test a human generated material or a human witness?
Yeah, we probably need a bot, right?
Yeah, well, and I've thought about this quite a lot. I mean, not just in the context of the kind of expert material that we've been talking about so far, but so you can imagine a wider scenario where let's say the subject of the arbitration, as it might well be, is a decision made or an action taken by an AI system. So, for example, you've got banks moving towards having AI systems providing financial advice to customers. Now, if the customer doesn't like, loses money, complains about it, sues the bank, and the case is whether the advice was negligent or not. In a conventional scenario where you have a human advisor, you bring the advisor in and you cross-examine them, and you'd be able to ask them what was the reasoning that led them to give the particular advice they did. Now, how do you do that with an AI system? I mean, does it make any sense to ask it about what its reasons were? I mean, we talked earlier about this idea about explainability and transparency, but a lot of these systems, particularly the sort of current range of LLMs, are effectively opaque by design. So, you can ask it questions and it will give you a plausible answer. But in no sense does it have any insight into whether that answer is true or not, whether it reflects reality. So, I mean, at the moment, it probably doesn't make much sense to talk about cross-examining AI systems because it's not going to reveal at the moment any very reliable information about how they came to the result they came to. And of course, there is the other possibility that if you're cross-examining an AI, perhaps that should be done by another AI. I mean, why not? One questioning another.
Exactly. Well, I'm not going to then prompt a question because there's a nice question that I'll ask the audience on specifically on that. So I'm going to leave it for later. But thank you. I agree. And that makes sense, right? So before we move on to what I think everyone is excited to see our live demonstration, we've now looked at all the theory and listened to everyone talk about the theory. Just quickly going to share again a question for the audience before we move on to the live demo. And the question is, what are the biggest risks when analyzing data with AI? Security, confidentiality, hallucinations, poor output, no human in the loop, or other. So if I can ask everyone to please vote. And then we will probably hear more about the risks involved. Okay, we've got 7 on no human in the loop. And this brings us again to how the human aspect is going to stay still much alive and involved. And hallucinations, yes. Okay, I think let's move on. I think overall the human aspect is a big risk, or remain always a big risk. All right, now I'm going to stop sharing and then hand over to Darren, who's our expert, and he's going to take us through his live demo. Thank you very much, Darren, and I'm sure everyone's very excited to see what you have to deliver.
Yeah, thanks, Sonia. And interesting, I'd love to know who the others there, what their opinions were on what would be the issues. I think that I don't know whether you can ask anyone there, but if not, we'll.
Welcome to pop it in the chat if anyone voted other.
Very interesting to know. So yeah, we've discussed a lot about AI evidence and how that is going to be made trustworthy. And as I mentioned, we've worked very, very recently and currently still are in a number of cases where that has been a focal point because AI had to be used to undertake a lot of the analysis, not opinion, but the analysis. And from that perspective, I wanted to walk through a quick demonstration of how we looked at ensuring that the evidence provided at the end of the day to the court could be trustworthy, and that from a forensics perspective, touching on the points I made earlier, and I think actually someone touched on it in the chat about the Dauer rules, that it could be repeatable, it was transparent, and was verifiable. So I'm just going to share my screen now. Hopefully everyone can see this. Sorry, get it up and running. Can you see that now?
Yes, thank you. We can see.
Perfect. So again, what we were looking for, and it's been touched on now very, very successfully, I think, in this panel, is that the platform itself had to hit all of the key aspects that we required for providing evidence for court, and that included the security and confidentiality, which we touched on already, but also dealt with a lot of the particular issues that popped up there in your quiz. So the requirements really were that we would need to be able to provide that evidence at the end of the day, whatever evidence we were providing. And this, by the way, this is a public data set, not the data set we were working on. We would need to provide that evidence so that at the end of the day, our methodologies and the evidence could be provided to the other side, and for them to be able to repeat the exact same process and within a margin of error be able to get the same result. And that was key to, as I said, to be able to trust what was provided. So we have a platform here. The platform is actually called Alchemy. I'm not going to touch too much on that for now, because it's not necessarily the platform. It's the process and the technology that needs to work hand in hand to ensure that the evidence is effective. Two or three major points to address, though, that this platform was able to provide to us. First of all, it only focuses on the data that we provide to it. So it does not go out to the internet. It does not supplement its knowledge through any external means. It only focuses on the information that is given to it. Now, that information could range from what we actually required, but it meant it was only answering based on that data. And that was a huge step in eliminating hallucinations, because when we're only focusing on the data that's been provided, as long as that data is accurate or it is meaningful, garbage in, garbage out. If the data itself is not helpful, then you're going to get not helpful answers from the AI. But it only focuses on that data, and it does that through what's called a RAG system, a retrieval augmented generative system, and that allows us to provide a level of trust in the outputs that it's giving. The second aspect was that it would allow us to run through or use large language models to actually run on our analysis. And that's actually just something I'm going to walk through right now. We'll do that using it's actually some public data from the BP oil spill. For those who are aware of it, back in 2010, a major issue in the Gulf of Mexico, Gulf of America, Gulf of Mexico, depending on where you are. And from that requirement, from that, there was a long-standing court case, which BP eventually lost. But what we're able to do here is start to take a data set that contains significant amount of information. In this instance, there's about 1,600 documents, long legal transcripts, and start to work an analysis. Now, I'm asking you to work with me on this one. Obviously, when we're working with arbitrations, we get data sets that are containing a multitude of different data types, maybe scanned images, significant issues that could potentially required in getting that information ready to undertake this kind of analysis. But as I said, if you go with me on that, we've already undertaken those steps. And what we want to be able to do is to analyze that information and identify, the key aspects that we might want to look at. So again, from a platform perspective, I'm able to look at really anything I want to in respect of those transcripts. So I'm just going to put in an initial prompt. That prompt, as many of you know, should contain certain information, like a bit of background to the case, what we're actually trying to ask the LLM to do, what we're actually trying to achieve, and potentially maybe some, format for the output. Just to save time with this one, I'm just going to ask it very quickly to identify the key aspects of the case, provide a timeline of the key events in a table format, and identify the key parties involved. Now, again, we went through a number of different platforms to identify which would be the best to allow us to undertake this work. The requirement that we had for the case was to deliver within 2 months. what would manually probably take 8 to 9 months to deliver. And to do that, as I said, we looked at a number of platforms. And again, where this platform stood out was the ability to identify through large amounts of data the aspects of the files that would be key to answering our particular questions. And through that, it actually very kindly summarizes the information first. And we can do that using a number of different large language models. And again, from a cost perspective, it's very helpful to use one of the cheaper models that's still very strong with summarization, but it keeps the cost down. Obviously, when using large language models, token cost is an issue. It's getting a lot better, as it is with the context windows getting a lot larger. I think, David, you mentioned 1 million. Google's new versions are up to 10 million now at this stage. So it is helping with increasing the amount of data that we can look at. But right now, I want to look at, just for the sake of exercise, I want to look at about 200 most accurate documents within the data set to answer my question up here. I'll explain in a second how that is going to work, and I'm going to use we'll stick with Gemini to answer the particular question. I'm going to click on that just to for the sake of time, and in the background that is going to run away and very cleverly analyze a number of documents and run what's called a computer-assisted review or computer-assisted learning process in the background, utilizing the large language models to summarize the information. And you'll see on the right-hand here, we start to get a relevance score. So it's looked at a few, it's identified ones that are more relevant to answer my particular question. It will then look at the next 50 or the next 100 documents with that relevance in mind. And in the same way, it's kind of ensuring that it's training itself as it goes, but in the background, using the large language models to inform itself as to the most relevant documents. And typically it's it's taking a little bit of time to do that. What will be key, though, and addressing what I just discussed at the start, is the fact that we need to be able to take the output. So in a second, I'm going to get a nice output to my question, but we need to be able to tie what it's saying to the underlying evidence. And again, what is key to the trustworthiness of our output is linking that information. And when we're talking about a forensic methodology perspective, we have a data set. That data set was the 1,600 documents that I had available to me. We have a prompt here. We'll get an answer that's from the AI, but we must be able to link that information to the underlying evidence. And again, from a platform perspective, the best or the most up-to-date platforms will be able to link to the documentation that it's using to provide the particular evidence. So you see here now it's producing the output that I've requested. You still need, going back to our points earlier on, you still need that human in the loop element. You still need to be able to review that information. You still need to tie it to the underlying evidence, and in that way, then, you know, as I said, the human aspect of it is going to be key to understanding, you know, that the output is actually accurate. And here you'll see I've got the key aspects of the case, the responsibilities, the cultural issues, which was a big issue with the actual particular problem, the technical aspects of the case, and what necessarily went wrong. I asked you to provide my timeline and the key parties involved. At all points in time, as you see here, I have the links that I can click on to identify the underlying document. So I've got my summary here, and I can review the actual underlying document itself, identifying that, or once read through, identifying that it is accurate. That QC element is critical to ensuring that the data set or that the evidence can be used going forward. If it's not, if you read it and you're not entirely sure If it's accurate, then again, that just suggests potentially that the prompt is off, that we may have introduced bias into the prompt, or that there may be some other aspect to it. But by following this methodology, so again, I'll just reiterate, I've got my data set that is a finite data set that can be shared with another party. I have my my prompt that I've used that can be shared. I have my answer here that I can share, and I have the evidential documents that back that up, and that can all be supplemented by, as I said, a human-led QC check, and that makes up my evidential bundle, pretty much for that particular question. I wouldn't suggest that we would use this. This is very, very high level, just to give you an idea. But it suggests exactly, if you were to focus on a particular evidential track, or an evidential track, that's the way, the steps that can be taken to ensure that output is verifiable, and, as I said, repeatable by someone else, giving them these aspects that I mentioned. Obviously, you would need to include what large language models were used, the exact models, because again, models will change drastically as the years pass. Even though a prompt will obviously not, if it's rerun, will not provide the exact same output as in word for word, because generative AI doesn't work that way. But the underlying explanations should be accurate. I'm going to potentially pause there. And maybe if anyone on the panel wants to ask any questions.
Yes, please feel free to jump in if you have any questions. Thank you, Darren. That was very interesting. And I think, if the panel doesn't have anything to ask, we can ask them about whether this output, as it is presented in the real arbitration, if it's presented to in a real arbitration, how it would be received in practice, and whether it would be persuasive. But Brendan, do you wanted to add anything on the demo?
Yeah, thanks very much, Darren. So I guess the kind of key to what this is doing is it's going to be agreeing the data set we're going to use and the limitations on that data set, and then potentially needing to agree a set of prompts, or at least disclose what set of prompts we're using. And as you say, as long as it produces the same output to an agreed degree of accuracy, then that's probably going to lead us to be able to trust the data set. If I summarize that probably right, so.
Sorry. Yes. Yeah. I think that's accurate, and I think those kind of steps can be agreed at the initial phases of the arbitration. And let me just stop sharing my screen. And yes, once they're agreed, there can be at a later point in time that verification process can be undertaken. That they data swapped, or well, the data should obviously be the same for both sides, but the prompts can be swapped, the outputs can be swapped, and verified at that point in time. But again, it's very key that I think, and I'm sure everyone's in agreement, that these discussions would need to be had very, very early on, so as to ensure all the parties are on a level playing field. Whether the technologies will be the same, I think that might be a bit different.
So to answer our very first question to the audience, whether the methodology is explained and whether the algorithm isn't fully disclosed, is the answer it should be. Darren.
So yeah, the algorithm.
Yes.
Sorry, was that question was to me, was it?
Yes.
Yeah. So the whether the algorithm itself, that's the large language model. Or are we talking about the underlying algorithms from the machine learning aspect?
Yes, and are we referring to, when we say the LLM, is that the language model you're referring to?
Yeah, so from my perspective, yes, you would need to notify which large language models you're using. All of the large language models have different characteristics, and therefore will potentially produce different results. So there needs to be that understanding upfront as to which models have been used. Some will be much stronger or stronger on numbers, for example. Some will be more verbose and add much more content and context. So yes, it will be important to include that. And again, from a verifiability perspective, to be able to take the data set, the prompt, and run it back through the same model, as I said, within that standard of error, that range of error, that you should get the same results.
Okay, thank you. Svetlana, did you want to add anything?
Just on the question, and if I can,
You can proceed.
yeah. If this was shared in the real arbitration, my view, I don't know how other arbitrators will see it, but will be met with curiosity and handled with quite cautiously. So,
Thank you. And David, Carlos, do you have anything to add, and whether this evidence would be persuasive if it's submitted in real arbitration?
I mean, I think if it was submitted to me as an arbitrator or a judge, I would regard it as a persuasive piece of written advocacy. It's not evidence. I mean, it's like getting a very well prepared written brief which sets out all the material and appears to be properly supported by references. So it will be, I think I'd find it very persuasive in that sense, but whether I'd be prepared to accept it as evidence if it was not agreed by the other party, then I'm not so sure.
Thank you. Carlos, would you agree with that?
Well, I'm not an arbitrator, so I'll go with David's answer on this one.
Right.
It was a very good one.
Well, if I can ask the audience here by show of hand, who would accept that as evidence? Okay, anyone? No. All right, nobody's raising their hands, so I think the
just
answer.
will add that in my personal view, again, this just will be the helpful understanding of the case,
Yeah.
but cannot be taken as evidence.
Well, Darren, I think we need to persuade them then on the evidence.
Yeah, I think maybe I hadn't made the point clear. At the end of the day, any statement needs to be backed up by that evidence. So there is a factual link back to an underlying piece of evidence or underlying document that can be shared and would obviously be shared. So any statement being made would quite quickly be identified as being true or false by the reading that underlying evidence. All we're doing here is maybe getting to a point where we're identifying that evidence much quicker.
Thank you. Yeah, it's a very helpful tool. Just into consideration for time, all right. Okay, then let's proceed then to looking ahead and what our institutions and practitioners' position is for AI evidence, the role of the institution protocols in South Africa. Carlos, the guidelines suggest that the institutions may create procedural orders or agreements regulating AI. How could these templates support AFSA or local South African tribunals? And what priorities would you recommend if an SA adapted protocol were considered?
Well, one of the things that we discussed a lot in the committee drafting the guidelines was that we should never over-regulate on this subject, right? So a lot of those things, as we mentioned before, a lot of the issues that show up when using AI are issues that already existed. They're just enhanced or augmented by everyone using AI tools at the moment. So in my opinion, ideally, you would try to provide ready-to-use guidance or rules, so everyone knows the best practice around using AI properly, almost as a checklist, something to guide people more than to determine how they should do things, and a checklist around disclosure, security, and fairness. I think those 3 points would be the 3 main ones. Maybe give parties a simple form where they could declare if AI is used and how, confirming that people stay responsible for AI generated outputs. I know it's obvious, but it's important to keep mentioning this, and even maybe addressing fairness, right? So we mentioned before that given like security and confidentiality issues, parties may use only providers that can enable that kind of environment to deal with sensitive data, but those cost money, and maybe not all the parties involved in a case will have those kinds of tools. And if one party has much better AI tools and can deliver their work much faster, the tribunal can still adjust the process, maybe share resources, maybe adjust the timelines around this, but most of all, ensuring flexibility for the local context, and technologists access across local firms, right? And maybe one last point is to adjust and align all of that guidance according to local laws on data.
Thanks, Carlos. And this is the question that I will direct it to Svetlana then. With Papaya and the GDPR overlapping, how can arbitrations remain compliant when AI process sensitive data or store information on foreign servers?
This is really a very real problem for us and very complicated in practice. Because POPIA and GDPR don't sit in neat and in separate box, but they overlap and data travels. So add AI on the top of that, and especially AI hosted on the foreigner server, and the compliance pictures get even more complex, not least. So from institutional perspective, we work on the basis of one regime, but 2 layers. The first layer is always POPIA because AFSA is based in South Africa. And in almost every case, at least one party or counsel or witness is subject to South African law. That means any personal information that is processed in arbitration has to be satisfied POPIA principles of lawful purpose, minimality, appropriate security safeguards, and specific condition for the cross-border transfer. Now, for the second layer comes in when we have EU, EEA, or UK party, or the data clearly relates to an EU data subject. Then GDPR will kick. This is GDPR style obligation travel with the data. Even if the seat is Johannesburg in South Africa, the arbitration can still trigger GDPR rules on international transfer, security measures, and data subject rights. So what happened when one drop AI into that mix? Particularly AI tools that sit on the foreigner cloud infrastructure. So legally, in that situation, both POPIA and GDPR will treat that as an export of the personal data. So to remain compliant, 3 things need to happen. First, there must be a lawful transfer mechanism under POPIA. What that means? Under POPIA, that means Either the destination offer protection sustainability similar to South Africa's, or you have appropriate safeguards or explicit consent. As per GDPR, that means that usual means and adequacy decision, standard contractual clauses, or some equivalent instrument. That is the lawful transfer mechanism. Second, there must be a contractual discipline with the AI provider. And before anyone uploads anything, the party and the tribunal should ask first, where are the servers physically located? Does the provider commit to POPIA GDPR equivalent security measures? Is the data encrypted in transit and in at rest? Who is the controller and who is the processor? And critically, is there a clear written prohibition of using arbitration data for model training or other secondary purposes? If you can get straight answers to all these questions, the safest legal conclusion is very simple, that tool cannot be used for arbitration and arbitration material. And now the third, there must be a data minimalization and how AI is used. Even with the right contract in place, you don't need to send the entire case file to the cloud. You just upload the minimum necessary, and where possible, you pseudonymize the personal data before using the AI tools, especially when these tools sit outside South Africa or in EEA. How do that in arbitration? How this happen in practice? So from institutional perspective, we should encourage the tribunal to capture this in the procedural order 1, or a brief data protection cybersecurity annex to be sent. That document can identify who is acting as controller and processor in relation to the case materials, and specify which tools, including AI tools, might be used and for what category of data. Then after record the transfer mechanism relied upon if data leaves South Africa or the EEA. And finally, set baseline technical measures such as encryption, access control, and retention limits. But if you think that we have just POPI and GDPR for that we need to comply with our arbitration, that is not the case. You need to add to that procedural framework as well the ICA New York City Bar CPR cybersecurity protocol and International Bar Association cybersecurity guidelines. So you will have the real picture of what we need to comply for our cybersecurity for our proceedings. So, and all there about the risk. So the answer to the question directly is yes, arbitration can remain compliant when AI tools process sensitive data and store information on foreigner services, but only if the party do the groundwork around lawful transfer mechanism, robust provider contract, and strict data minimization. And no, it is not enough to say we use AI because it was convenience. Convenience does not override the statutory data protection duties. So from an institutional standpoint, AFSA direction of travel is clear. We will support AI and cloud tools with security by design and law by design framework.
Thank you, Svetlana. There's a lot of information and a lot to digest in terms of what protocol protection and cybersecurity is relevant for FIRE and GDP and all the rest that you mentioned. So just maybe for sake of time, let's maybe move on. I'm not going to open to the rest of the panel, but maybe just for Brendan and David, if I can ask you, just briefly, should arbitrators and counsel receive structured training on assessing AI evidence? And should future tribunals be assisted by digital clerks or neutral AI advisors? David, if you want to start.
I mean, I think it's certainly useful for them to have training to deal with the point that we were discussing before, which is it's not at all easy, if you're not familiar with the area, to know how to treat the reliability of material that's produced by AI. Should they be assisted by digital clerks or AI advisors? Yes, why not? I mean, and I think in the future we will see that happening.
Yeah, I agree. Brendan?
Yeah, so I think I agree with David. I mean, if there's training, that the training is useful, and it's never going to go amiss. In relation to the kind of use of digital clerks and neutral AI advisors, I think I touched briefly on the use of kind of expert assessors to assist arbitrators previously, and I think it may be a situation where you've got to leave that up to the arbitrator you select. If he or she needs the help, that help should be available to them. But I think it's the situation where you may not be able to force them to take the help. But I mean, personally, I would. So.
Sonia, did you mean by that the digital clerks would themselves be able to?
No, not necessarily. I mean, look, I mean, I guess it would depend on the situation and kind of as we go. But I think, as David, you're probably right. If it's available, why not use it? If it's going to make the arbitrator or judge's life easier and potentially help us get to a resolution faster, which I think is where the world is heading.
Exactly. And that's going to bring us to our last question, and also the question to the audience. But first going to pose this question to the panel, and fast forward to 2030, what realistic and beneficial uses of AI evidence will we see in South Africa within 5 years? Will AI enhance human decision-making or begin to share in it? So anyone on the panel, if you want to answer that, please jump in.
With two words, I think we'll be assisted, not autonomous. So we'll be not decision maker.
Thank you, Svetlana. Carlos, David, Darren, Brendan.
I'm going to make a bold prediction. I'm going to allow myself 7 years till 2032, but I think by then it will be entirely feasible to have automated systems that will simply absorb all of the material that's given to them by both sides, and will come up with a decision on that material which is indistinguishable in quality from a human decision.
Thanks, David. 7 years. Okay, we will see in 7
You
years.
can come back in 7 years and see whether
So I may add just
Yeah.
to David. So I think in the document intelligence, authentication, and forensic and analytics, mostly, probably we will have it as, again, assistive role. But this is my view.
I agree. Carlos, thank you. And Darren?
Yeah,
and
I'm not
Carlos?
gonna be so bold like David on this. But you know, if we could use AI to check properly the authenticity of digital evidence, which is something that is still not possible, that would be great. If we had that by 2030, and maybe help tribunals manage cases more efficiently. I think that's a realistic one.
Yes, I agree. Darren?
Yeah, maybe just to add, I think we're absolutely going to have much more AI-based evidence, so AI-created evidence. And by that, I mean evidence, you know, from the Internet of Things, from Edge AI, these kind of more data coming into arbitration from the start, which is going to require much stronger large language models, or much stronger, at least, AI-based methodologies to analyze and identify information to get to a point where we're getting to David's side of things where it'll do everything. But again, with the large language models now increasing token sizes and context window sizes, exponentially, I think, that I wouldn't put it past David's 2032 that we would be achieving that.
That was a good time to look forward to. Brendan, last point from you.
Yeah, I think I agree with David and Darren. I think at least at potentially a site level, there may be use for a certain agreed class of dispute or class of argument that comes up to potentially have as a first leg, that there'd be an AI kind of view taken on what the likely outcome of that is. Obviously, with the parties still being able to go to the kind of general ADR principles and kind of up the chain, but it may just speed along smaller disputes and not end up in situations where the work on site comes to a grinding halt because we're waiting for a long dispute process to take place.
Thank you. I'm going to share in the meantime, just quickly for the panel, for the audience, the next question. Do you think we'll see an AI-assisted arbitrator in South Africa by 2030? Let's have your views, please. We've heard from the panel. Let's see from the audience. Okay, yes, 11, 8, no, not sure, 2, 12, okay. So majority agree that by 2030 we will have AI-assisted arbitrators. I think the question should rather have been, yes, I support that, or yes, I don't really, but I don't support it. Okay. Moving on, last question or second last question. If AFSA or the CIR could do one thing to prepare us, what would it be? If you can talk just briefly. I see that we've already received a few questions from the audience in the chat. I want to leave at least 5 minutes just for questions. So just quickly have a look here. Training and lectures, offer training access to a suitable universal platform, more training, test an AI system and let us know it works and is safe. AI training. Okay, I think overall training is definitely the forefront on everyone's minds. Would be creative for more training mechanism, human response training. All right, definitely training is at the forefront.
From AFSA, this is already for 2026 international commercial arbitration training AI section is included. So we're good.
Great. Okay, AFSA is prepared. Thank you very much. You'll send us the information they can apply online. Okay. I'm going to just have a quick last question for the panel. And I literally want one word just from, I'm not going to open it to every single panel, but maybe just one person from the panel, because just for consideration of time. One action CIR or AFSA should take now to integrate AI responsibly. Okay, Svetlana, thank you.
Adopt clear institutional guidance.
Okay, thank you very much. And then somebody else on one skill every arbitration professional should build for their AI era.
I can answer that.
Thanks, David.
The skill is phlebotomy, taking blood samples. And the reason for that is that there was a recent Microsoft paper issued about which jobs were at greatest risk of becoming redundant as a result of AI. And phlebotomists were at the top of the list of people whose jobs were safe. So that's what we should all be looking for.
Well, the audience is laughing, so So that's quite scary to think that we will be taking blood samples, but thank you for the sharing. And then lastly, who carries responsibility if AI evidence misleads the tribunal? The expert, the tools developer, or the party that's relying on it? And maybe if I can ask Darren and Brendan and Carlos each to have a quick say.
The obvious answer is Darren.
I agree.
Cheers. Thank you. Appreciate it. No, I would suggest that, you know, from the bottom up, there needs to be a clear kind of demarcation as to whose responsibility it is at each step of the way. So absolutely, I think from an evidence perspective, it will be the experts, but that needs to be obviously verified by the legal teams and further ahead by the arbitrators. So there will be responsibilities at each step, but they need to be clearly defined at the start.
Thanks, Carlos.
Is it the same question? Who is responsible?
Yes.
Yeah, the party and its expert.
I agree. Thank you. Then just one quick last question for the audience. In one word, what should define South Africa's approach to an AI arbitration? Integrity, innovation, or caution? And then we will move on to questions from the audience. Okay, caution seems to be taking the lead. Oh, integrity. Yeah. Okay, integrity. Okay, thank you very much. I'm going to, in the meantime, open up to some audience questions, but just to wrap up, human judgment remains essential. I think from today's session, we can see that it is important to know that the humans aren't going anywhere, but AI, when it's used wisely, can raise the evidentiary bar and strengthening fairness. So I hope that you all have taken some valuable information from today's session and learned a lot in terms of what the future is for AI evidence and where it fits in. And I'm going to open the questions. So if anyone have questions, please pop in some questions. And I believe that we also have questions on our chat. I don't see any questions coming through, so I'm not sure where that's going to be raised, but I'll check it on my end. We have some questions on the chat. I can quickly run through these questions. There are 4 questions. Just quickly from Charlton Rex, given that courts in the US apply the Daubert standard, requiring expert evidence to be reliable, peer-reviewed, and generally accepted, how should arbitral tribunals approach the admissibility of AI-generated evidence, which often lacks transparency and peer validation? Anyone on the panel want to answer that question?
I think we kind of did touch on it at various points during our session today, but you know, that idea that we would have accountability, that would have the verification, that QC process, and that ability to provide an evidence pack that can be verified by another side is key to having that admissibility question.
Thanks, Darren. And secondly, from Sanele, firstly, a comment from my side. I am more regularly using AI to research legal topics, each inquiring inquiry being required to cite accessible references. It works well. However, especially with case law, the fundamental rule is never cite or rely on case law without having read the case itself. Be able to distinguish between the obiter dicta and the ratio decidendi is a must. Understand the question. Maybe the question is, should it be able to distinguish between the obiter dicta?
Well, I think the what's going to be key there is the prompts that you use, and I think what the takeaway there is, once you get the kind of AI spits out the cases that support whatever you want to support, you're going to need to make sure that that human QA QC element comes in, and you go and check those cases to make sure that just because it's told you it's the right case doesn't mean you can take it as the gospel truth. So I think you need to read it for yourself. It may help you limit your searches, or at least guide you in the direction your searches are going to go, but it's never going to take away your duty to make sure that what you're putting down or what you're putting before the court is you've confirmed in your mind is correct and supports what you want to support.
Yeah, and that touched again on that human aspect to make sure the evidence that you put forward is correct. There's a question from the audience. Are arbitrators using AI in making decisions? If so, how widespread is the use of AI by arbitrators? This was on the Q&A. Someone in the room probably. Anyone on the panel want to answer this question?
Look, I don't know, like to make decisions, I'm not sure. When we were drafting the guidelines, we could see a lot of arbitrators still being very cautious on using AI. And the fear there was that AI could start iterating with them in a way that would bring up angles on that dispute that weren't raised by the parties and that the parties couldn't comment on before they made the decision. And I was very impressed on how everyone was being good about this. But then I did an event in the branch in Brazil where I'm from, and basically they told me like that most arbitrators there are already using it for a lot of things within their cases. So I would imagine that this is very jurisdictional or cultural specific. On I think it would have an impact if you come from a tradition in which the decision maker can make decisions based on the law in general and not just by what has been argued by the parties, which is not an acceptable standard in international arbitration, but it is an acceptable standard on many different jurisdictions. So I would say that it will be different depending on where you are, but there is definitely people already using to draft procedural orders and timetables.
If I also can answer by example, last year in Johannesburg Arbitration Week, we have a moot court while the award being drafted by AI and the live tribunal based on the same pleadings and submissions. And the result was quite interestingly, actually absolutely opposite. But we think is that because when the award was drafted, there was these human touches and consideration that one algorithm cannot get it. And of course, the result was absolutely show that. So what decide the human tribunal was absolutely opposite of what decide the AI. So I think this brings to the answer how AI should be used in arbitration, and if the arbitrator can use AI, to what extent.
Thank you, Svetlana. We have a few more questions. I don't know if we'll have time to go through all of them, but maybe another two. What would the national our AI guidelines drafting process look like? Multiple international bodies are working on the AI and digital innovation regulations, but it will be timely and might not have weight. What would it look like? I think we've touched a lot on this in your last question, but at least Svetlana. So
It's already a lot and is now with the CR guidelines as well. So it's work in process and we're developing as we go ahead.
yeah, it's always changing. And as Carlos also mentioned to us before, you know, with the AI guidelines of the Chartered Institute of Arbitrators guidelines, there's already changes that needs to be implemented, and you know, it keeps on changing. So we learn as we go.
Yeah.
So I think we've dealt with that, yeah.
Yeah, and I know the IBA also has a committee working on some guidance around AI, and they're already starting from a different point of view, and then they will progress. So I would imagine that all those institutions will contribute to the discussion and to how well we progress with creating best practice around the use of AI.
Yeah, thank you, Carlos. Next question, I think it's specifically for David. Imagine you're examining an AI expert, an LLM. How do you address placing it under oath, and how do you qualify the expert witness, particularly taking into account its psychophantic tendency? Psychophantic tendencies. Whoa, thanks for those big words. David, over
Well,
to you.
I think the I can't sell my video. I think the short answer is you can't. It's not that kind of process. And as I said before, tempting though it is to kind of anthropomorphize these systems, they're not conscious or thinking entities. They can't swear oaths. They can't know whether they're telling the truth or not. They're not really witnesses at all in that sense.
Thank you, David. Next question, and maybe our last question. Do you see a situation in future where the use of AI by arbitrators or the parties become compulsory in arbitration so as to shorten proceedings? Compulsory?
So again, as I was saying earlier, I think it's difficult to make anything compulsory because that means I'd have to make sure everyone has the same access, has the same, is using the same tool. But I can definitely see there being suggestions or timelines in disputes being tighter, which would probably lead to AI tools having to be used. But I can't see a situation where you could tell a party, this is how you must run your dispute.
I think the last question will be, we'll deal with this. I see these two questions on bias. How can you determine that the AI that is used does not have an built-in bias? And I'm just going to read the second one. To what extent can the adjudicator's decision be set aside on the bias that the AI protocol has been compromised by the adjudicator, i.e. fairness of not applying himself to the merits of the matter? So who wants to deal with the issue of bias?
I would say that you cannot determine if AI has a built-in bias currently, but I could be wrong. But I cannot see a way of testing this.
Darren, have you come across it where you've seen any bias?
Yeah, so obviously with the large language models right now are inherently trying to please. So I think that goes back to the sycophantic question earlier on. But and by trying to please, they're obviously potentially introducing bias. I think the best way to counteract that I've seen right now is to try to limit the implications of the bias within the prompt. So framing your prompt, and obviously earlier on we just showed a very quick one-line prompt. Prompts can go to 30, 40 lines in trying to ensure that the accuracy of the information that comes out. And one of those lines could absolutely be to frame the documentation, to frame what has been provided, to frame the particulars, potential of the bias in the documentation. so as to ensure a much more balanced response. But yes, we're never going to be able to be 100% sure of the bias being introduced from the training set of the large language models. We can just try to limit it in.
Thank you, Darren, and Carlos, David, thank you very much. I just want to mention that we've had quite a few people online, and Dr. Chikwendo Madumere is the African trustee of the CIR, and we've also had the African branch chair that was online. So we thank you for also attending, and we appreciate them being online. But I just want to say to my panel, all the panel members, thank you very much for joining. Carlos, Darren, David for being online, and Darren for taking us through that AI example. And I believe that we will see a lot more AI evidence, and we'll learn as we go on. And hopefully, David, by 2032, we will see our AI arbitrators in practice. But thank you, Carlos, also for sharing some of the guidelines. And I hope that we will see more coming out, and then from AFSA's side, adopting the local regulations and see how that develops with AFSA and the CIR locally. And Brendan, thank you for your insight. And for everyone here tonight, thank you. I really appreciate it and online. And I really hope that this was a insightful event, and I hope to see you at the next one. So let's now go and enjoy a refreshment for those that are here in person, and online, please go and do the same on your end. Thank you very much, everyone.